Hi, I'm Todd Christensen, Senior Risk Control Specialist at ThiCap, and I've got another safety short for you today. Today, I want to talk about law enforcement interactions with the public, whether it's a voluntary contact, investigatory detention, pat down, or an arrest. Those are four distinct categories, and I want to talk about those today real quickly. Before I go any further, one thing you want to make sure is that you do have a policy in place that talks about and discusses these types of interactions. It's important to understand the distinctions between these types of contacts in order to avoid violating a person's civil rights, whether it's violation of the color of their skin, the age discrimination, gender, whatever it might be. It's important to understand these types of distinctions so we can initiate the contacts and be within the confines of the law. There's four types of contacts: voluntary contact, investigatory detention, pat downs. It can include a pat down or not, and then there's arrests. A voluntary contact includes a person who is engaged by law enforcement but has no obligation to interact with that law enforcement individual. So in other words, the law enforcement officer has a right to initiate a contact in any place that law enforcement has a right to be. And in most cases, that's the general public areas. It could be a park, it could be outside the front of a store, or maybe even in a store or on the road. But they have a right to approach an individual and initiate contact. And it could be just a simple question, it could be just to establish rapport, whatever it might be. It is important to understand that that individual being contacted under a voluntary type contact has the right to refuse questions. They have a right to leave at any time. They basically have no obligation to cooperate with that law enforcement officer. In order to engage an individual, it's important to establish rapport, professionalism, and not to come off as intimidating or appearing to detain that person. It would make it much more likely that that person would cooperate. An investigatory detention is based on reasonable suspicion that a person has or is actively committing a crime, or that a crime may be committed, and that person is detained for questioning but is not under arrest. To initiate this type of contact, you have to have explanatory evidence, perhaps visual evidence of a person actively engaged in committing a crime, or perhaps you have information that that person has a weapon on them. Again, it has to be explanatory. This type of detention may or may not include a pat down using plain touch or plain view rules. And hopefully you understand what those are and you have policies in place based on those types of pat downs. Again, this type of investigatory detention is based on reasonable suspicion, and that explanatory evidence must exist. An arrest may be made based on probable cause, such as observations, physical evidence, or informational evidence presented by an informant or other law enforcement individual. Arrest warrants may also initiate an arrest. And if you're going off an arrest warrant, you have to ensure that that arrest warrant is accurate for validity. We want to make sure that we're apprehending and arresting the correct individual, and that the arrest warrant gives the authority to do that. I have seen at least one claim where there was a person who was apprehended, arrested, and I believe then detained in a jail setting, and it turned out that that was not the correct individual. It was a mistaken identity. Well, that initiated a claim, and it was a pretty big claim. So I don't know if that was a result of an arrest warrant or if it was just a general arrest, but regardless, we have to make sure that when we're making these arrests that we have the proper person in custody. Of course, at any given contact, and probably more so once you get into a detention or arrest type situation, there could be physical altercation or obviously a need to physically apprehend somebody, touching, placing hands behind back, placing cuffs on that person. If there's any resistance, the least amount of force needs to be used within reason. There are laws out there that stipulate chokeholds, anything that's involved with grabbing the neck or restricting airflow is illegal. Now that's, again, you cannot do that unless your life is in danger, or there's immediate danger to life and health of the arresting officer or perhaps the general public. It's also important to keep in mind that arrestees, once arrested, those arrestees do not have a right to leave the detention area for whatever reason, unless extenuating circumstances exist. So if somebody gets arrested and they say, I need to go get my coat, or I need to get a personal effect of some sort, no, you do not let them do that unless there's an extenuating circumstance. That could be very subjective. So you have to have, again, good reason to let that person leave the area. But at the same time, if that choice is made, you have to ensure that that person can be still detained, monitored. Perhaps you escort the person to go wherever they need to go. So, there's going to be some flexibility there, but it's up to the discretion of the officer how they want to handle that. So again, there's 4 types of contacts. There is the voluntary contact, the investigatory detention, we have pat downs and arrests. The distinction between the 4 need to be understood, how to approach it in order to avoid claims. And of course, if we don't approach these interactions correctly and we do have claims, there's always the PR backlash, careers can be ruined, departments can have a bad reputation for those types of things. So have a good policy in place, train to the policy, understand it, and hopefully we can avoid claims and other situations that we don't want to get ourselves into. So again, my name is Todd Christensen, Senior Risk Control Specialist with ICAP. Thank you for watching.